Hello friends, I am Dr. Harsha Suryavanshi, Assistant Professor from Sri Shivaji Law College, Parvani, Maharashtra. In this video, we will discuss about provisions about written statement provided under Order 8 of Civil Procedure Code. Now, what is meant by written statement? Written statement, it is a reply to a plaint filed by the plaintiff. Written statement is filed by defendant. Therefore, we can say that written statement is pleading of defendant. What should be there in the written statement? The written statement must deal with every material fact alleged by the plaintiff in his plaint. The defendant shall also mention any new facts that are in his favor, or if he has any legal objections against the claim of the plaintiff, he shall state those legal objections in his written statement. Now let us see what are the rules about written statement. Now who can file a written statement? Obviously it is the defendant or his authorized agent can also file a written statement. If there are more than one defendant, then a common written statement can be filed by all of them provided the written statement is signed by all the defendants. Now, when the written statement shall be filed? Rule 1 says that after service of summons, the defendant shall submit his written statement within 30 days. However, this period of 30 days is extendable up to 90 days and not more than that. Therefore, we can say the defendant can submit his written statement within 30 days, and if he is not unable to submit due to genuine reasons, in such circumstances, the court may extend the period but not more than 90 days. Now let us see what are the particulars or other rules of written statement. Rule 1 of Order 8 says that it is the duty of the defendant to produce all the documents which are referred in his written statement and on which the defendant relies. How the document shall be produced? The defendant shall prepare a list of documents that are relied by him in his defense. He shall state in the list the documents that are in his possession. What about the documents that are not in possession of the defendant? In such case, the defendant will have to mention in whose possession or power the documents are. What will happen if the documents are not submitted according to Rule 1? If the defendant does not submit the documents at the time of filing of written statement, he will not be allowed to read those documents in evidence unless the court permits him. However, this rule that the documents must be submitted at the time of WS has two exceptions. This rule does not apply to the documents that are reserved for cross-examination of plaintiff's witnesses. Similarly, the rule also does not apply to documents that are handed over to witnesses merely for refreshing memory. Now let us see other particulars. What Rule 2 says that new facts must be specifically pleaded. For example, if according to the defendant, the transaction is either void or voidable in law, the defendant shall mention it in his written statement. Similarly, there may be facts which are not present in the plaint, such as fraud or limitation or payment or performance or illegality. Such facts must be mentioned in the written statement. The objective is that the plaintiff shall not be at surprise at the trial. Whatever the defenses or legal objections of the defendant are there they must be clearly mentioned in the written statement. Now, rule 3. It says that the denial must be specific. It is not sufficient for a defendant to deny generally. He must deal specifically with each allegation of fact which he does not admit. But this rule does not apply to damages. Now, how the denial should be? According to Rule 4, the denial should not be vague or evasive. The denial must be dealt with each and every allegation of the plaintiff. For example, if it is alleged that defendant received a certain sum of money, it shall not be sufficient to deny that he received that particular money. But how he will have to deny? He will have to deny that he received that sum or any part thereof. He will have to deny it completely. Now let us see other particulars. How the denial should be. Rule 5 says that the denial must be specific. Rule 5 says that every allegation of fact in the plaint, if it is not denied specifically or by necessary implications, then it shall be taken to be admitted. However, this rule does not apply to persons under disability. Therefore, the plaintiff will have to deny the facts or the allegations specifically. Rule 5 further says that if written statement is not filed by the defendant, then court may pronounce judgment on the basis of the plaint. And if court has pronounced the judgment on the basis of the plaint, the court will draw a decree accordingly. Now let us see about Rule 6. Rule 6 says or speaks about particulars of set off to be given in WS. What is meant by set off, we shall see in other lectures. Similarly, Rule 6A to 6G speaks about counterclaim. Set off and counterclaim are defenses of the defendant. And these things, set off and counterclaim, will be dealt in by separate videos. Now let us see other rules of or other particulars of written statement. According to Rule 7, when the defendant relies upon several distinct grounds of defense or set off or counterclaim, and these are founded upon separate and distinct facts, they should be stated separately and distinctively. Again, if there is new ground of defense which arises after institution of the suit or presentation of written statement, and it claims a set off or counterclaim, the same may be raised by the defendant in his written statement. Rule 8 speaks about circumstances that are occurring after presentation of written statement. Rule 9 says or speaks about subsequent pleadings, or it prohibits subsequent pleadings. Rule 9 says that pleadings shall not be allowed to be changed after filing. However, the court may allow any party to alter his pleading upon such terms and conditions as the court thinks fit. That means it is the discretion of the court to allow amendment in pleadings. Rule 10 speaks about procedure when party fails to present his written statement within the time. It says that the court may pronounce the judgment against him or pass such order in relation to the suit as it thinks fit. The court will draw a decree accordingly. Thank you, friends. Thank you very much.